Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. We hold this community conference call every 2 weeks, every other Thursday, subject to all the disclaimers that you heard while you logged in. I'll begin first with the frequently asked questions, which I think are asked a lot by the community, and today I have actually a bunch of them. After each question, I will pause and ask you if you have any follow-up questions. At that point, if you have follow-up questions, you can press *5 on your telephone, and that would indicate to me that you have a question, and we'll be happy to take it at that point of time. Let's just make sure you can hear me okay. Just 1 second.
The conference is now in conversation mode.
Will you confirm? Can you all hear me okay? Hello?
Yes.
Okay, thank you.
Yes.
Very good.
The conference is now in presentation mode.
Let's get started with the first question that I have marked as a frequently asked question. This is question number 2. So this is about employees outside the US. How can we continue the green card through consular processing? I have a valid I-140 from the old employer. Can we file green card from abroad through my previous employer if they are willing to hire me back? And the answer is yes. If they are willing to hire you back, you can apply for a green card as long as there is a good explanation for number one, why did you leave? So for instance, if you had a personal reasons for leaving, but you never abandoned the intent to join them back. And 2, the employer had the intent to hire you back. And the job was never eliminated, because if the job is eliminated, arguably the green card is terminated. So for instance, let's say you have a job of a chief technology officer. And when our acting CTO leaves, we eliminate the position and have another position above that, maybe director of technology, who substitutes for the CTO. So it can be argued that the job is gone. So there are these 2 issues, your intention and the continuity of the job. As long as they are all answered, there is absolutely no problem. The law does not require you to hold the green card job presently. Okay? Of course, this should be discussed with your lawyers. Make sure everything else is in order. But those are the 2 main issues, and definitely it's worth looking into. So the answer is yes, you can. Second question is, as per my knowledge, I cannot file green card through consular processing. However, if I move back to the US, will I be able to file I-485 without joining my old employer? And the answer is still the same. If you move back to the United States, let's say you get an H1B and come back, and you are working for some other employer, can you then file an I-485 when the dates become current? And the answer is only if the old employer is willing to take you back even at that point of time. So both the 485 and the Advance Parole, the consular processing are based upon the same principle that you will be hired back. My only concern is if you come back to the United States, why are you not working for them already? So again, as long as these questions are answered satisfactorily, there is absolutely no problem in principle. So if somebody is outside the United States, they can still continue to process their green card. Press *5 if you have a follow-up question on this. Okay, I'm going to move on to the next question, which is EB3 to EB2 interfiling after using Advance Parole, and then reverting back to EB3 if needed. So the question is, my priority date is 2014, current in the June visa bulletin. I'm planning to go to India this month and returning back next month. While coming back, I will use my Advance Parole. My wife is already using her EAD and Advance Parole. Question number 1, can I interfile if I use AP to enter the USA? The answer is yes. USCIS has made it clear And if you go to my blogs on immigration.com, you will see that the USCIS has clearly said, even if you have used the advance parole, we can still have you do your interfiling as long as the dates for final action are, or final action dates are current. Second, now this is a little bit more complicated. Can I go back to EB3 again if the EB2 date is in retrogression? And the answer is, USCIS has said that you can only do this once. I don't know why. I think that's an incorrect application of the law and procedures, but that's what they have said. Therefore, it is still possible, but you can't interfile. However, in my view, you can always file another I-485 to also activate the EB3 from which you have already taken out the pre-existing I-485. So I see no problem with filing a second 485. *5 if you have a follow-up question on this. Press *5 if there is a follow-up question. Moving on to the next frequently asked question. I-485 interfiling to use EB2 instead of EB3 with a new employer. Okay, so here employer A filed I-140 EB2 which got approved, switched job to employer B. Employer B filed I-140 and 485. I don't know how they did that because they would have to have started their own green card. This wasn't a downgrade from EB2 to EB3. This I-140 also got approved. I guess so they also filed a perm. So employer B also processed a green card. They also got the I-140 approved. Switched jobs from B to C. Employer C only filed H1B and I-485J. So the situation is, with employer A, you had an EB2. With employer B, you have an EB3. Now with an employer C who had only filed a 485J, basically porting your EB3 over to employer C, can employer C convert me back to EB2? The answer is no, they cannot. Because employer B's EB3 was inherited by employer C. Employer A's EB2 is not, you never filed a 485, so that cannot be used. Since my priority date became current in EB2, what would be the best option for me? Either go back to the first employer. If they have a job offer, you can actually apply for a 485 without joining, but this should be discussed with your lawyers in detail. There are some thorny issues. They have been mentioned in our frequently asked questions. They've been discussed several times. Just go ahead and take a look at that. Okay, so yeah, you could file for a 485 based upon the job offer and I-140 which was approved through employer A. But if you want to stick with employer C, either you stick with EB3 or you start another perm application through them for your EB2 categorization. Okay, *5 if you have a follow-up question. Press *5 on your telephone, please. All right, let's move on to the next frequently asked question. How long can a green card holder stay outside the US? So we have discussed this many times. Once you get your green card, technically, if you leave the United States with an intention not to come back, you have abandoned your green card even if you're gone just a day. So if today I just sell all my stuff, sell my car, get rid of my house or get rid of my house lease, and I leave the United States thinking I'm never going to come back, I go to India or Philippines, wherever I'm from, I stay there a week or 10 days, and now I want to come back, it can be argued that I've already abandoned my green card because I left with an intention not to return. That's the first principle. How about the corollary of that principle? I left for just a day, but I ended up staying there 4 months, 5 months, 6 months, or a year. I got stuck, for example, with COVID. It can be argued that that's not a loss of your green card because there's a good reason why you couldn't come back. So As a practical matter, if your visit outside the United States is less than 6 months, you are not put through extensive questioning by the Customs and Border Protection when you return. So less than 6 months is usually okay as long as you have not abandoned your home, your job, or your work, whatever you're doing. If you are doing remote work, you're still doing it. So the point is, a green card holder can stay outside less than 6 months. Of course, a few weeks here and there is never a problem. But let's say you're gone 5 months and 25 days, it can be asked, what were you doing, etc. But normally, 99% of the times, there is no extensive questioning if your visit outside is less than 6 months. So in this particular case, we have somebody who's going to India for 4 months. Is this going to be an issue with the CBP when I come back? No. First of all, always tell the truth, whatever the truth is. If it is less than 6 months, it should not be a problem. Does it negatively affect you in any way? No, I don't see why. What typical questions? Normally, I don't think you will have any extensive questioning because a green card holder who is returning in less than 6 months is not put through extensive questioning. Is working for a US employer from India allowed? Well, first of all, you should not be working in any of the export restricted areas, or for example, I don't know, it's 256-bit encryption, that's considered to be weapons grade. So any kind of technology or export restricted items, as long as they are not implicated, you can work from anywhere. Do I need to expect a secondary inspection? So if it's less than 6 months, no. There is no secondary inspection usually. Okay? *5. If you have a follow-up question on this, press *5 on your phone. All right, let's go on to the next frequently asked question. Actually, today I had a whole bunch of questions that I thought were frequently asked questions. How about, can a green card be filed when an employee works outside the United States? Absolutely. Absolutely. There is no requirement that you must be in the United States when your green card is filed. Any kind of green card, it can be filed while you are still outside the United States. A second question relates to optional practical training approval. So while somebody is waiting for the OPT approval, do they have to be off the payroll altogether? Or can they take an unpaid leave of absence? And in my view, if you take an unpaid leave of absence, you're just getting benefits or not even benefits. As long as you're not working, you're fine. I do not see any problem with it. I do not consider this to be a violation of the student status. *5, if you have a follow-up question, press *5 on your telephone. Okay. Let's go on to, this is another good one. This is a good question. So as you folks might know, I think most of you do, that there's something called AC21 Portability, which means once my I-140 is approved and 485 has been pending 180 days, I can take my green card process and move it over to another employer with the same or similar job. So that way I don't have to start the green card again. The same green card gets transferred over to an employer who has never processed my green card. So definitely that's a process which is quite well tested, quite safe most of the times, but the jobs have to be same or similar. Now this is not the same thing as porting your priority date. Priority date can be ported to totally different jobs. So I always give this example. My first degree is in biology and chemistry. I could get my green card filed as a lawyer, but then I decide, you know what, I would rather be working in a lab and become a research scientist. I could port my priority date from a green card filed as a lawyer to a green card filed as a researcher. So priority dates can be ported to any positions, but AC21 portability requires same or similar job. So the question here is, what the heck is same or similar? Okay. And I have mentioned, and they actually were kind enough to post a link to something I had said. And I'll not refer back to it. I'll just tell you basically, same or similar means one job prepares you for the other. That's one example. So it could be a promotion. So one same or similar idea is, let me explore a couple of concepts. Let's say we look at technology. Somebody was an Oracle systems administrator, okay, and then they changed their job over to SQL, MS SQL or MySQL system administration, or even some kind of a mid-range mainframe database administrator. The essential nature of the job is database administration. So even if the technology is changed, in my opinion, it is still same or similar job. That's quite a drastic opinion, but that's my opinion. Okay. Second example of this is a promotion. So let's say you worked, your green card was filed as a software developer, but the next job you have received is the director of software delivery. Okay. Now here what has happened is, this is a promotion. The previous job, which is a developer, prepared you for the job of a delivery manager. Okay. So therefore, it's still same or similar. The only time you would have a problem is if you filed as a lawyer and you want to port your job over to over as a scientist. Those two are not same or similar. So the question that were being asked were, Rahulji asked me, if you change your job but transferring your H1B and not use EAD, would AC21 still apply? That's a very interesting question. In other words, what he's asking me is this: I want to change employers, I want to do AC21 portability, but I want to use H1B. Absolutely okay. There is no law that says in order to enjoy job portability, you must necessarily use your EAD. In fact, in 99% of the cases, I would advise you to transfer on H1B, simply because if there's a problem with your 485, we are on solid footing to fight it out. Otherwise, you would be out of status and unlawfully present if your 485 is denied. So definitely keep your H1B active. That's the smart thing to do. Second was, the same or same determination, USCIS looks at all aspects. Job duties. Do the actual job title and duties need to be a dollar-to-dollar match? No. No. Because, for example, look at the way software developers are in the industry. Somebody is called a programmer and they are still a developer. Somebody is called a software engineer and they are still a developer. Somebody is called a software architect. They are really still a developer. So it all depends. It doesn't have to be a one-on-one match. Job location changes. Can I move from one state to another? Absolutely. That's a part of AC21. Compensation differentials, positive or negative, I think they are all included. Only time you'll have a problem if there's a huge jump down or jump up without a proper explanation. So what is the proper explanation? For example, if I move from Little Rock, Arkansas to San Francisco, my salary will probably be tripled because I'm going to a high wage zone. That's one reason why I'm getting so much money. Or if I get a great promotion, and that's allowed under the same or similar standards. So if the compensation is unexplained and it's a huge jump, it could become a problem. Always have your case reviewed by a lawyer who understands your particular area or is willing to talk to you and learn about it, so they can assess whether the two jobs are same or similar before you make any firm plans, okay? *5, if you have a follow-up question, press *5 on your phone. Area code 608. 608, where are you calling from?
Calling from Wisconsin. Namaste, Rahul. Rajiv sir. This is Rahul.
हाँ जी जोशी साहब. How are you, sir?
कैसे हैं?
बहुत बढ़िया. बहुत बढ़िया.
एक चीज आपने आइटम में शायद फिर से मैं पूछूंगा. Job mode changes, are they allowed? Like maybe if your original job was on site,
Oh.
nowadays, as you know, lots of those are
Yeah,
getting
yeah.
more hybrid,
No
fully
problem.
remote.
No problem. I think of
Okay,
that
because
as a non-essential condition because when we compare same or similar, the fact that the job's mode has changed either from hybrid to completely remote, I don't think that should make any difference. Okay?
okay. I mean, the reason I asked was because in that H1B side of the house, they have that Neufeld memo and employer-employee relationship, and is it observed or is it
No, no.
properly implemented now?
Hang on. See, we have so many right now in the COVID environment. Just to give you an example why I think it's irrelevant. In the COVID environment, I'll give you an example of our office. Our Arlington office is completely remote. We are not working from the office at all. Stanton office people are working. India offices people are working. But in Arlington, people are working completely remotely. And even if there are 3 people working from the office, but they are doing it voluntarily, not because we have asked them to. So just because circumstances are such that people are working from home, or even a job is such that people are working from home, because of COVID, we have realized that a lot of what we do from office can be done from home if we have the right workflows and infrastructure. So in our case, for example, all we
Right.
need is a scanner and great internet connectivity, secure cloud. As long as we have all those things, we can work from anywhere. Voice over IP telephone system. So, I don't think that's a major issue. I would not be too concerned about that.
Okay. I was listening to your response to my question, and you kind of made an interesting statement when you were addressing the technology differential. You said that they would be allowed, in your opinion. So, for example, let's say, and I'm taking your example, where someone was working on Oracle administration, and now that person is transitioning over to maybe SQL Server administration. Now, my question is, does USCIS understand these things can happen? Because it's not you and me, and even it applies to, the mode of operation from hybrid to remote. I mean, what we understand is not relevant. It's what USCIS people understand. So do they understand these things, typically based on your experience?
Well, that's why the good Lord made the courts. When they don't understand, then we take them to court. Okay? So typically what happens is, I'll give you this. USCIS as an organization is amazingly stupid. But USCIS officers individually are very smart people. Okay? So the problem is bureaucracy by itself is very stupid. But individual components of the bureaucracy are very smart people. I'm constantly amazed by the depth of knowledge of both Department of Labor as well as USCIS employees. So, of course, if you run into somebody who has no idea of technology, doesn't understand how the law is implemented, is working on the job the 3rd day, you might have some difficulty. But if you are able to make a presentation and that is comprehensive enough to explain to anybody how this works, you should be able to win that case. I have always, last 30 years of my practice, I have always prepared cases for the court. I never prepare only for the USCIS. Because if you lose, that file will go to court. You can't change the file. You better have a complete file. Today I did a consultation where the file is so incomplete, I have no choice but to do something to complete the file before I take it to court. So, do they understand it? They normally do. And if they don't, that's our job to make sure they understand what we are saying and how the law is to be implemented. And if they still don't agree with us, then that's what the good Lord made the courts for. And by the way, here's another interesting point. What if my AC21 is denied? Can I file another AC21 through another employer? I would say yes, I can. Okay, how do I do it procedurally? That's something we have never had to confront. I must have done hundreds of these AC21 cases, never had an issue, not even once. So part of the reason is understand the statute. The statute, which is American Competitive, Competitiveness in the 21st Century Act, AC21, was enacted to provide relief to people who were stuck in the same job. So these are called, I forget the exact name that is given to these kind of statutes. They are to confer some benefits on people. When you have a beneficial statute, it is always to be interpreted in the most beneficent terms. You have to give benefit where benefit is intended. You can't try to restrict it. So, in other words, I think you're protected from several angles. Rahulji, just make sure that your jobs are reviewed by your lawyers and they feel comfortable with them.
Sure.
Okay?
And it can also be a natural transition, right? So, for example, if you are working, again, picking your example, if you are working as database administrator, and now you are taking a role that says you are now a senior database administrator, I think that should be including that mention in the title. That should be allowed, right?
Absolutely allowed. I have done it several times. We do it all the time where people have gone from being, let's say, an ERP developer to even a CTO, a Chief Technology Officer.
Oh.
Okay. So even if it's 2 promotions or 3 promotions, it's a vertical move. And I think it is within the spirit of the statute.
Okay.
All right.
And then I think you partially answered that last question of mine. I didn't put it, but this is relevant too, is what happens in general if your I-485J gets rejected based on that same similar consideration? Like typically, what's the next course
And
of
that's
action
what I said. I have never had to test it, but I believe that you can file another supplement J. Because think about it, the procedures have changed. Now you actually get a response on your supplement J, yes or no. That does not mean your 485 is automatically denied. I could always file a second supplement J, right?
But you cannot file it for the same employer, which means you have to
Why
change
not?
job again.
Why not?
Possibly.
Why not? Why not? So let's say that I am working for Oracle and I moved to IBM and IBM said, you know what? We don't use Oracle, we use DB2. So you are now a DB2 administrator or a lead DB2 administrator. And the government comes back and says, no, you can't be doing this. You have to be a system admin, not a lead. Okay, fine. I'll file a supplement J for a system admin. I don't see why not. Okay.
Okay, interesting.
As long as it
But
is
even
genuine, as long as it is done in good faith, we are not trying to cheat the government. They can't stop me from my benefits. They can't. Okay.
Nice. Okay. Thank you so much, sir. Thanks
You're
for your
welcome.
time.
Good
Great
luck.
discussion.
Good luck. Okay. Next question is about naturalization. Oh, wait. Did I cover this? Yes. Next question is about naturalization, jurisdiction and place of residence, and traveling while the application is in process. So let's do a quick review of the naturalization rules. First of all, you must have had your green card, and I'm assuming simple, ordinary employment-based green card. If you are married to a US citizen, the times are different. So let's say you have a green card based upon employment. You should have had your green card for 5 years, 90 days less than 5 years, because you can apply 90 days ahead of time. Out of that, 2.5 years physical presence in the US is required, 30 months. If you were outside USA, you were never gone for more than 6 months. That's the easy one. If you were gone for more than 6 months, less than 1 year, you will need an explanation why you were gone that long. And that's the traveling part. If you travel for less than 6 months, usually you're not questioned. More than 6 months, you could have a problem. Make sure you talk to a lawyer. And the last thing is, if you're gone for a year or more, you have lost your green card presumptively. But during the COVID times, we have been able to get people back in even though they were outside USA for a year, year and a half, because Customs and Border Protection was allowing that. But that doesn't mean that your eligibility for naturalization won't go away. So reviewed, 5 years green card, 30 months physical presence, never outside USA for too long, you're good to go. Now, traveling. So when you travel for less than 6 months, even while the application is pending, you can do that. Jurisdiction. You have to file where you have been domiciled for 90 days at least. So it's not like you're living in Texas and you can file in California. That's not allowed. You have to be living where you apply for naturalization. Okay? I think those were the only two questions. Star 5, if you have a follow-up question. Star 5. Okay? All the frequently asked questions are done. Now let's go back to the non-frequently asked questions, after which we'll start new questions. Let's see. So this one is question number 4. Maintaining H1B status and traveling back to the US with advance parole with 221G case status. So here the bottom line is this. My I-140 is pending. I traveled to my home country. I'm assuming it is India. I applied for my H1B. I got a 221G for the visa stamping. But I have my advance parole. Should I travel back on my advance parole? Lawyers are saying don't do that because that will abandon your H1B. Well, you see, I can only give you one recommendation. There's a lot I can talk about, but I would rather have you talk with your own lawyers. I don't agree with them completely, but that's a difference of opinion. Everybody is different, entitled to their own opinion. I will tell you this. Wait until you get the RFE. If the RFE is relatively simple, by all means travel back on advance parole. I am not worried at all. Because you can always reactivate your H1B by applying for a visa stamping further down the road, if necessary. I don't know what the 221G is about, but the bottom line is wait for the RFE. That's the smart thing to do. If the RFE is simple enough, travel back on advance parole. Don't worry about it. Star 5 if you have a follow-up question. 201 is New Jersey. New Jersey, go ahead, please.
Hello, Rajiv sir. Yeah, it's Sandeep here. This is my question.
Yes, sir.
So I received the RFE
Achha.
information.
What is it about?
The RFE is very basic as per my lawyer.
So then travel back on advance parole. Why are you stuck? Why are you stuck there?
Yeah, so the RFE is to prove that my employer can afford my payment.
Yeah, that's not simple unless, it depends. If the employer has enough money and enough in their tax returns, your lawyers and your employer can help you with that. But if your RFE is relatively simple, why not come back on advance parole? Absolutely do it. Okay?
Okay.
Good luck.
Thank you.
You're welcome.
Okay, thank you.
You're welcome, sir. All right, next question. Next. This one is from Ahmad, number 6, question number 6. Change of status, F1 OPT to H1B and switching employer during green card process. So, hey guys, don't call me Rajiv, sir. Just call me Rajiv, please. I have 3 years remaining on F1 OPT plus stamp. Okay, got it. You are not from India or China, so we are assuming you're not from a backed up country. You have also been picked up for H1B. Question number 1. Is it better for me to switch to H1B? I think it is always better. Absolutely better. Question number 2. At what stage during my green card process I can safely switch my current employer? What we were just discussing just a moment ago, which is AC21 Portability. We have a huge, big discussion on that today. Okay. So AC21 Portability is, first your perm will get approved. Then your I-140 will get approved. 485 and I-140 would be filed at the same time. 180 days after that, after the I-140 is approved and 485 has been pending, you can change employers to a same or similar job. Okay? Star 5. If you have a follow-up question, press star 5. Okay? We did this. This one is L2 visa holder traveling. Question number 8. L2 visa holder traveling while spouse's visa status is changing from L1B to L1A. My husband is getting his visa status changed to L1A under premium processing, but my I-539, which was filed along with his application, is under normal processing. In case of his L1A is approved, can I exit and enter the US before my present visa expires? Yes, you can. Yes, you can. I don't see why not. Will the date in my I-94 extended for the same duration of his approved petition automatically? No. There's nothing automatic here. You should, when you come back, you have a visa that will be valid for a certain amount of time, but then you would have an approval, L1A approval. You should carry that with you. And if it is at all possible, I would send an email to the consulate before you travel. So before you travel out, just check with the consulate. I think you can travel with the same visa and with the L1A approval. Okay. You can also contact the Customs and Border Protection via telephone. They actually respond to phone calls. So if you go to cbp.gov, you can call them up. And L1, L2 are automatically eligible to work these days. Okay. So, and you don't need EADs anymore. That's no longer required, as you know. So your I-94 has L2S mentioned already. So you don't really need your EAD. Okay. So in my view, you could travel, but when you come back in, make sure you present your L1A approval. But before you do any of this, because this is a rather unusual situation, double check with the CBP and the consulate. At least try. I don't think you should have a problem. *5. If you have a follow-up question, press *5. Area code 720. 720, where are you calling from?
Hi, Rajiv. I'm calling from Colorado.
Yes, ma'am. Go ahead.
Yeah. Rajiv, as you said, I must call CBP via telephone.
Mm-hmm.
So before I travel, for example, when I posted this question, the visa, my husband's visa was not approved, but now it has been approved.
Oh.
He's on L1A now, and he will be receiving his petition in a week's time, I believe.
Okay. Okay. So in my view, you
yeah.
should be,
So,
you should be able to travel, but double check anyway. I always double check these things. Immigration law is full of surprises, pleasant and unpleasant. Okay. Keep going. Keep going.
Yeah, Rajiv, actually my concern is I'm already working. So my I-94 will expire on June 20th.
Okay.
So my concern is my organization is saying that if you get your I-94 updated, then we have no concern. You can work.
Sure.
Because it has L2S, as you already stated.
Right.
So now I'm thinking of, I have two options. Either I go to India or I cross the border by land by going to Mexico. So those are the only two options. So should I call CBP office or should I directly go to Mexico, the border?
Since Mexico is an option, if I were you, I would write it down. I would call the Eagle Pass Bridge Customs and Border Protection Office. Eagle Pass Bridge.
Okay.
This is in Texas.
Okay.
Texas-Mexico border. So Eagle Pass Bridge, what happens there is they have a process where you can pay $10 and they will give you a new I-94 without you crossing into Mexico.
Okay.
Okay. This is the only office.
I can give my husband's approval to them and I can tell them after this.
That's why I want you to call them before you travel there. But I think they might be able to do it very safely without you actually having to travel outside the United States.
Okay. So they listen the complete case over the call?
They should.
Respond?
They should. We have had good experience with them. Yes.
Okay.
Okay.
Okay. And I should tell them that I'm doing this because of my job.
You don't have to tell them that. You can just make your case concise. I have an L2 visa. I have an I-94. I-94 is about to expire. I have a visa stamp. But my husband has promoted himself from L1B to L1A. I have his L1A approval. Now I have a current visa stamp. Can you give me an L2 I-94 based upon my existing visa and his approval, L1A approval? It's as simple as that.
Okay. And I just have one question. In case they say, no, you have to cross the border. So in that case, my present L2 application, which is the I-539, which is under processing, can it be revoked? Because
No.
I-94 will change.
No, it cannot be revoked because you can travel during a pending extension as long as you have a valid visa. You can't travel when you have a change of status, but when you have an extension, you can travel.
Okay.
Okay?
Okay. I mean, if I do it before my present visa expires, there will not be any problem.
That is my opinion. Yes, ma'am. I think that's how it should be. Okay? Good luck to you.
Okay. Thank you, sir.
You're welcome.
Thank you.
Bye-bye.
Yeah, thanks a lot.
You're welcome. Okay, so H4 traveling back to the US. This is question number 9. H4 traveling back to the US while H4 extension is pending. My wife came to the US on 6th March on H4. She had to leave in May. My employer's lawyers were in the process of filing H4 extension. My wife wants to come back, and her visa stamp will expire in June. She'll come back before then. So her extension is probably no good because she traveled before it could be filed, right? They were in the process of filing extension. They filed both on May 17th and she left on May 10th. So yeah, here's the easy part. She can travel back on the same visa stamp, but they'll have to refile for the H4 extension. They'll have to file a new extension after she returns, okay? That's an easy question. *5 if you have a follow-up. *5. Okay. So then the next one, oh yeah, this is from California. Yeah, California, go ahead, please.
Rajiv, thank you for your clarification.
Uh-huh.
So her extension will need to be filed again.
Yes.
And because these extensions take a long time to get approved,
Right.
she can she travel using that extension after her visa expires?
So no, she'll have to get a new visa stamp. Now, understand the difference between an H1 and an H4. When you are on H4, you don't need an H4 approval to get an H4 visa stamp. You get the H4 visa stamp based upon the H1 approval. So we don't care what happens to her H4 with the USCIS. Okay. When she's in India in June, she can take your H1 approval and apply for a new visa.
I am, as per my lawyers, my company's lawyers, I can continue to work for 240 days while the H1B is pending because it has been filed in normal processing.
Right.
But that does not allow her to travel back and forth
No.
without a
No.
H4 visa stamp in her passport.
No, it does not. And in order for her to extend her H4 visa, she will need your H1B approval.
Okay.
All right.
And her H4 extension is not
needed.
Not valid because it was filed.
It is invalid because it was filed. Hang on. It was filed after she left. It's not valid. And for her to get an H4 visa stamp, she does not need that extension. She only needs your H1B processed. What else? And if she returns before the visa expiration, she can then file an extension, no problem. Okay?
Okay. All right.
Good luck.
Will that need to be a completely new I-539? The new
Yes,
extension?
it will. Okay?
Okay.
Good luck.
All right. Yeah. Thank you, sir.
You're welcome. Okay, so next question. EB3, this is question number 10. EB3 priority date, retrogression and consequences. I have 2 approved EB2 petitions, for one approved in 2012, employer A, one in 2016, employer B. I'm now with employer C. Oh, I already dealt with this, didn't I? Somehow this looks familiar. Maybe not. A lot of employer A, B, and C today, I guess. Okay, going back to what you were asking. Now I'm with employer C. Since my date was current for EB3, C filed for my AOS along with I-140 AP and EAD under EB3. How did they do that? Did employer C start your green card? Are you on the phone? Press *5 if you are here. This is Hari. Hari, are you here? Okay, excellent. Area code 636. Where are you calling from?
I'm calling from Missouri.
Missouri. Okay. So did the employer C also start your green card?
Correct.
Okay. So they had also gotten their I-140, or they were at the I-140 stage,
Correct.
right? Okay, good.
Correct.
Current employer filed for my AOS along with I-140 AP and EAD under EB3. Just after a month, the dates retrogressed, and I'm not sure what to do. So think about it this way. Employer A and employer B both have EB2 petitions approved for you?
Correct.
Okay. So you could actually get another 485 filed through employer A or employer B. There is a lot of frequently asked questions. We have discussed this issue in detail. When you are trying to file a green card through a past employer, what requirements have to be met? So either one of them could file based upon your good faith intention to join them back. But the current employer cannot file an EB2 for you if they processed your PERM as an EB3. If they processed your PERM as an EB2, then you have options.
Okay. So if employer C has to file under EB2, they have to start from scratch, is it?
They have to start from scratch. Okay?
Okay. All right.
All clear?
Thank you.
You're welcome. Good luck.
Yeah.
Good luck. Yeah, it's so much nicer to just have you here so we can talk, because otherwise it would have been impossible for me to write a comprehensive or respond comprehensively. So the next question, somebody from area code 281. 281, where are you calling from?
Hello, hi sir. I'm calling from Texas.
Yes, sir.
My question is also related to this question.
All right.
And my question is actually number 5. I'm
5.
sorry, I missed.
Okay, I'm not going to repeat myself.
Late, so
Hang on.
What you said.
Hang on. I'm not going to repeat myself. I can tell you that already. You wait till the recording comes up, and then you can hear it. Question number 5. Actually, I made that into a frequently asked question, so that would be quite extensively dealt with. So wait for it, and when the recording comes, you can hear it. All right. Good luck.
Okay. Thank you.
You're welcome. Somebody else had their hand up. I just saw that. Area code 608. 608, where are you calling from?
Sir, this is Rahul again, and I have a question about this current question, a follow-up.
Okay.
That you just answered for Mr. You made a comment, sir, if your current employer C, in this case, that, Mr. Hari's current employer,
right,
if he had filed his, PERM and 114 EB3, then that could be an issue. That was originally filed in EB2, then probably it would be easier. So could you talk a little bit more on that? Because
yeah.
I was trying to understand.
So what happens is, remember there are 2 different dates operating here, or 2 different processes operating here. One is transfer of priority date, and that's what interfiling does. It takes your priority date from EB3 to EB2, EB2 to EB3. That's a different set of issues. And then you have AC21 Portability, which takes whatever category you have, whatever green card you have, over to a new employer. So if you were transferring AC21 under EB3, you will stay in EB3. If you are transferring under EB2, you will stay in EB2, right? Now, here the situation is this. We got 3 employers. A and B have EB2 filings done, I-140 approved, but the third employer has EB3 only. So now if I want to file a green card, I have 2 choices. EB3 with the current employer or EB2 with any of the past employers. But the interesting thing is, if I file EB2 with any of the past employers, with all the good faith intention, everything being in place, too many things for me to talk about, but as long as the filing is perfectly done, after 180 days, I don't even have to join them. I can do same or similar with the current employer. And now I am on EB2 with the current employer.
Okay.
Yeah, there's a lot of different moving parts here, difficult to keep track of. Let me go on to the next one, Rahul. Take care of yourself.
Thank you, sir. Thank you so much.
You're welcome. Area code 281. 281, where are you calling from?
Hello, sir. I'm calling from Omaha.
Yes, sir.
Yeah, I have a follow-up question on the same topic. What if the employer C has only filed H1B and 485J only? Is it possible for interfiling?
No, you cannot. You cannot.
To use EB?
Yeah, you cannot. Because that EB2 was not filed by this employer. So you cannot convert your supplement J-based job to another category. You are stuck with whatever that job category was. Okay?
Okay.
Good luck.
So if the employer C has to do something, he has to start from the scratch.
They have to start from the very beginning. Do a pump for you. Okay? Good luck.
Okay, but I can move to employer A or B, correct?
Yes, you
At
can.
any time.
Yes, you can. And we have a lot of frequently asked questions on that. Just go back and take a look at immigration.com. We've been discussing this issue for the last 6 months, ever since interfiling became a real thing. There's also some information on my blog that you can read. Okay? Good luck.
Thank you very much.
You're welcome. Okay, I think I have another one from area code 678. 678, where are you calling from?
Rajiv, I'm calling from Atlanta. This is quite related to the same topic. There's only one slight difference I wanted to check. So if you have a previous employer I-140 approved, my current employer, if he in the process of filing my green card, once I-140 is approved, can I go ahead and use the previous I-140 priority date, number one?
Absolutely,
and
yes.
without changing my employer?
Yes, absolutely. Priority dates do not require you to join the old employer. Priority date is your property, not the employer's.
Understood. But is that same and similar job? Obviously, right? Also the
it doesn't have to be.
Different,
It doesn't have to be same or similar. When you are transferring just the priority date, it can be totally different jobs.
Okay.
All right.
Thanks.
Good luck. Good luck. Okay, so the next question, which is number 14. Is F4 visa applicable for a child over 21 years of age? So the idea here is that my uncle applied for my mother under the sibling category for US citizens, which takes 14-15 years. Now, how does the CSPA protect me? So if on the date your category becomes current, which is your mother's category and yours, of course, derivatively, we subtract your age. From your age at that time, we subtract the number of days, months, or years the I-130 was pending. And if you are below 21, you are entitled immediately get your green card. Okay. So on the date, your priority date becomes current. You are under 21 based upon the I-130 deduction. You should be able to inherit the green card. Star 5. If you have a follow-up question, press star 5. Area code 973. 973, where are you calling from? Hello? Can't hear
Hey,
you.
Rajiv. I'm calling from Maryland.
Yes, sir.
Hey, I think, there was a connection issue. Yeah, I'm calling from Maryland.
Right.
Hi, Rajiv. So, I think that's good. So, I had one follow-up question on this. So, do I have to be in India at that time? Like,
See,
when this gets current? Right now I'm on F1 visa?
Hang on. I think it's an interesting question. I can debate the fine points of the law, or I can give you a practical solution.
Yes.
The practical solution is simply this. Stick on the green card through consular processing. Just take a couple of weeks, 2 or 3 weeks off when you are called for an interview. You go get your medicals done, get your other formalities completed. Do the interview, you get your green card, you come back. It's not going to be too long a stay.
Okay. It's not going to be too long.
Yep. All right.
Okay. And another thing on that, can they, what are the things they look for, when they give you an immigrant visa, what are the circumstances under which they could reject it? Or what are the criteria they judge?
Basically, either crime or a contagious disease.
Okay, safe on that.
Okay, good. So you're safe on that.
Yeah.
You didn't rob a bank recently. Yeah. You have been avoiding all kinds of contagious problems. You should be okay. Other than that, ability to support depends upon what your uncle's ability to support, etc. is. But all that can be taken care of through co-sponsors and all. So really, the two issues that are the most common are crime or contagious disease. Okay.
Okay. Is there any way that we can predict it? My date is April 2006 and the current thing is on September 2005.
Nobody can really predict the movement. Somebody asked me to do that and I said that's an astrologer's job, not an attorney's job. So nobody can really predict. We can make guesses, but they're not good. Okay?
Yeah. Rajiv, yeah. Just one more question. So just on this, so it's under process. So if I engage in something like day one CPT, can it hurt this application?
Okay, one second. Let me close the conference because I don't want any new people to log in. Give me 1 second.
The conference is now locked.
Okay, the conference is locked. So no, I don't see why day one CPT should hurt this process at all. Just don't do anything that's fraudulent or a misrepresentation. Other than that, nothing can hurt your green card. Okay?
Okay. That sounds good. Okay. Thank you so much, Rajiv.
You're welcome. Good luck. Okay, anybody has any question? Press star 5. I'll take you in the order that you logged in. Press star 5. Anyone has any question? Okay, the 3 most recently joined, 42 minutes ago, 33 minutes ago, and one is 53 minutes ago. So we have 4 total, and I have closed the conference so nobody else can log in. 53 minutes ago was Phoenix, Arizona. Phoenix, Arizona, go ahead, please.
Hey, Rajiv ji, this is Pankaj from 602 area code.
Yes, sir.
I wanted to check with you that, one of my family member who is traveling on visitor visa here and filing extension for him for next 6 months, and looks like there's a long wait time. And if extension does not come, or if for some reason overstay happens, and his wife plans to travel from India while this extension period, does immigration officer can have objection for his wife to travel?
No.
Because husband has overstayed.
They should not, as long as she carries proof that they have applied for their extension. By the way, Google my name, Rajiv, Rajiv, S. Khanna, space The Economic Times. In The Economic Times, I have an author page in which I have written a comment on extensions and the problem with extensions. So read that, just a 5-minute read. Read that, but as long as the wife carries proof of legal extension, I don't think they should give her trouble, but it's difficult for me to predict. Government can create an issue out of anything. The practical solution is let her clear her immigration in Abu Dhabi, let her fly through Middle East. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Okay. Now, somebody who's been waiting 44 minutes. That's Wisconsin. Wisconsin, I can hear you. Go ahead, please.
Only one quick question.
Yes, sir.
How do you, if I want to talk more and request a consultation with you, sir, how do I do it?
A consultation. Okay. What you do is, easiest thing is just send me your questions via email, help@immigration.com.
Sure.
I'll assess how much time we need.
Okay.
I'll forward it to our front desk. They'll set up a call with you. Okay?
Okay. Thank you, sir.
You're
We have
welcome.
talked before. I remember.
No problem at all. Good
Thank
luck. Okay. Next one, waiting 44 minutes. Atlanta, Georgia. Georgia, I can hear you. Go ahead, please.
Rajiv, good afternoon. This is Himant here.
Ji.
I have a quick question. I booked Dropbox for my wife. My H1 is approved, but her is in progress. But I know that it can be stamped while she go to India. But one quick question is her, the what do you call, for employment, I processed the H4 EAD. So will that be impacted before her H4 is approved?
Okay, that's a little confusing. You said she has an H4 and she has an EAD. So I'm assuming what happened was
EAD is applied.
EAD is applied. So
EAD is applied.
her H4 extension is pending, correct?
Pending, yes.
Okay. So she traveled while the H4 extension is pending, which is allowed. Should that impact the EAD? The travel shouldn't impact the EAD. Even getting a visa stamp should not impact the EAD. If anything, it might make it a little quicker.
Okay.
What you need to do is, coordinate with your lawyers. When she comes back with the visa, see if you can update the USCIS records with the fact that her H4 is already approved.
Okay.
Okay.
Got it.
Good luck.
Thank you.
Okay. Second last question today, which is, let's see, area code 224, which is Illinois. Illinois, go ahead, please.
Hello, Rajiv. This is Srikanth. I have a quick question about my son's situation.
Yes.
Can you hear me okay?
I can hear you fine. Thank you.
Okay. Let me give a quick background. So he is on H4, 18 years old, and his H4 is expiring on July.
Okay.
In July.
Okay.
So we're in the process of filing extension, H1 extension. He actually received his GCEAD this week.
Okay.
So he's planning on to use the GCEAD because he found a summer job. Next month he'll start using it. So my two questions are, what would be the impact on his EAD if we proceed with the H4 extension?
Well, the H4 extension is pretty.
Question,
hang on. The H4 extension is pretty much useless because if he uses the EAD, he has opted out of the H4, and he's now on authorized period of stay based upon his 485, which is fine. As far as your H4 is concerned, it's like you can let it go on, but it's not worth anything anymore anyway, so it doesn't matter. Not a big deal.
Okay. So technically, that's probably my second question. You can answer, but I'll still ask. So now that he'll be on EAD, right? What is the status considered as?
Authorized period of stay. Yeah, authorized period of stay simply means you are legal to stay in the United States based upon certain conditions. So he fulfills all the conditions, basically doesn't work without authorization, doesn't rob a bank. He's good to stay as long as his 485 is pending, no problem.
Correct.
Okay.
Great. And then for his college, right, we use H4. He is a freshman in his college. Do we need to do anything there?
You don't really have to, but I usually just go ahead and inform the DSO that you can show my status as adjustment of status pending.
Okay. So worst case, right, now that let's say we decide H4 and we got the H4 approval, it will not impact the EAD because they are completely separate.
No impact.
Let's say if for some reason he ends up he wants to use H4 for whatever reason, right? So he just goes back, leaves the country and comes back on H4. That's okay, right?
That's
He's
perfectly
back on
okay.
H4, correct?
Yep, absolutely.
Okay.
Good
Perfect.
luck.
Yeah, thank you so much.
You're welcome. And the last question is from area code 310, California. California, go ahead, please.
Yeah. Hi, sir. This is Vinod, and I'm from California, Los Angeles. Are you able to hear me?
I am, yes.
Yeah. So actually, the thing is, I have my priority date is March 20, 2014. And from June, my date will be current. So in October 2020, I have applied for EB3 and I got the EAD and AP, but I have not used it. I'm still on H1. And I was just thinking now on EB2, should I interfile or can I go ahead and refile it? Which is the best option for it?
Is your I-140 under EB3 still pending?
No, sir. It is also approved. Everything, both the EB2 and EB3 I-140s are
EB3 I-140 is approved. Did you file a 485 with the EB3?
Yes, sir.
Okay. So I think interfiling is a good option for you. You don't have any children who are turning 21 or something, right?
No, not right now.
Okay. So yeah, I don't see any problem if you just do an interfiling. I think that's the smart thing to do.
Okay.
All right.
Thank you, sir.
Good luck.
Yeah. Thank you.
Bye. Well, folks, that was the last question of the day, and it's always good to see you all. I'll see you again in 2 weeks. Stay well. Bye-bye.